Today, once again, I am going to recapitulate the rules that are applicable with regard to acceptance. Now, first, let me enumerate the rules. Number one, rule number one, acceptance must be communicated. In that, there is a division. Silence cannot be prescribed as a medium of acceptance. But silence amounts to acceptance. You should not actually confuse between the two. Silence that is being prescribed as a medium of communication is different from an instance where silence itself amounts to acceptance. I will explain this later. Then the third principle is acceptance concludes contract. Now, when you take acceptance, when people are physically present and facing each other, when a person makes an offer orally and another person conveys his acceptance orally, they can alter their position because they are facing each other. But in law, a question may arise when one person is residing in one place and another person is residing in a different place, in a remote corner. Now, when the person who makes an offer through post, when do you say an offer sent through post is said to be concluded? And when do you say that an acceptance that has been made by the other person in the other region, when do you say that acceptance is complete? So let us analyze this when we deal with that particular rule. The third important rule is the acceptance must be before offer lapses. An offer lapses when it is not accepted in the prescribed manner. An offer lapses when it is not accepted within the prescribed time. An offer lapses by revocation, which may be express or implied. An offer lapses by counteroffer. These are the rules with regard to offer that has got to be accepted within a reasonable time and in the prescribed manner. The next rule is an acceptance. An acceptance must be made by whom? When an offeror makes an offer, who is the person who has got to accept it? An acceptance must be made by the acceptor. When offeror makes an offer, the offer must be accepted by the offeree, who is also known as the acceptor. So no other person can accept other than the offeree. Then acceptance sent through email or acceptance conveyed through telephone or through electronic medium. When do you say the contract becomes concluded? In such of those instances, the acceptance is said to have been concluded not at the place where the message is conveyed, but it is only concluded at the place where the message is received. So I have enumerated all these rules. Please bear this in mind. Now let us go one after the other, the rules which I have now explained. First, acceptance must be communicated. Just like offer that has to be communicated, acceptance also must be communicated. Unless acceptance is communicated, how can the offeror know that the other party has accepted his offer? So, acceptance must be communication. Powell versus Lee is a leading case, where a person applied for the post of headmistress position. The committee, education committee, which was fixed for appointment of staff, it passed a resolution that a particular candidate whose application was considered to be very suitable they accepted it and passed a resolution. Immediately, the secretary was told to draft a suitable letter and an draft agreement, to be sent to the candidate who has applied for that post. But meanwhile, what happened? That particular candidate, through his own friends who happened to be employees there, she came to know that she has been appointed. To that effect, they have passed a resolution. Instead of waiting for the letter of communication, she immediately filed a suit. I understand that a resolution has been passed appointing me as a headmaster. Why you have not so far appointed me? So immediately the court said, on what basis you have filed a suit? Have you received the communication? Have you received the order appointing you as a headmistress? No, I am yet to receive. Then how can you come to the court? Unless acceptance is communicated, you cannot come and file a suit. The order must be received by you. So acceptance must be communicated. Then another case, Progden versus Metropolitan Railway. This is a case where the railways wanted certain members, customers who have applied for supply of iron. They actually agreed to supply iron ore. And this quotation was actually examined, analyzed, and it was decided in a particular committee that a particular customer must be allowed to supply this iron ore. But the message was not sent. Without receiving the message, immediately the member filed a suit. That what is it that I have not received anything? See, I understand that my quotation has been accepted now. It was said by the court that unless you receive the order from the railways, you cannot file a suit immediately. You must have some basis on which you can file a suit. Without receiving the order of acceptance by the railways, how can you file a suit? So, acceptance must be communicated. Next, I told you, silence cannot be prescribed as a medium of communication. Silence will amount to acceptance. That is different. Silence cannot be prescribed as a medium of communication. Feldhaus versus Bindley. I have already explained this while narrating the various rules regarding offer. Here, in one case, Feldhaus versus Bindley, an uncle wrote a letter making an offer to his nephew to purchase his horse. And the uncle in the same letter wrote, if I do not hear anything about the horse from you, I will take as if you have accepted to send the horse to me, to sell the horse to me. But meanwhile, what happened? By the time the letter was received from the uncle, the nephew had already sold the horse. The uncle actually thought that his nephew has sold the horse to him. And when the horse was not sent, he filed a suit. The court said, you see, you cannot actually assume on the mere fact that the nephew has not sent a reply, you cannot assume that he has sold the horse. Silence cannot be prescribed as a medium of communication. But you find this position completely differs when we take up our practical experience. For example, income tax authorities, sales tax authorities, they send what is known as pre-assessment notice. They wanted the assessee to reply within 15 days. And they say, if we do not receive a reply from 15 days from you, we will take it as if we have accepted our order of notice, our order of assessment in the notice. So, this definitely, it speaks valid from the point of view of the government procedure. If you do not reply within the prescribed time, then it is assumed and presumed that you have accepted it. Well, this is one of the orders and rules. Therefore, you must know the difference between silence that is being prescribed as a medium of communication and silence that amounts to acceptance. Having said these rules, I am going to yet another rule, namely the third rule, acceptance concludes contract. Now, when we speak about acceptance here, we are going to explain that acceptance and offer that are exchanged through post. When people are facing each other face to face, being physically present, there is absolutely no difficulty. It is only when an offer is sent by post by one person to another, and the other person also sends his acceptance by post, the difficulty arises as to when exactly contract gets concluded. Now, Section 4 of the Contract Act clearly explains. When do you say an offer is said to be concluded? In other words, when do you say the communication of an offer becomes complete? The communication of an offer is said to be complete only when it reaches the knowledge of the person to whom it is made. Take for example, humorously, let us give an example. Supposing hero writes a letter to heroine. Unfortunately, that letter does not reach the knowledge of the heroine, but the heroine's father, who is a villain, he receives the letter. Now, can you say that communication of an offer, has it become complete? Certainly not. Why? It has not reached the person to whom it is made. Even granting the heroine happens to be an illiterate, even if she receives the letter and somebody else misinterprets that letter, even then we will say that offer is not said to be complete because heroine has not got the knowledge as regards the offer made by the hero. Therefore, the offer through post is said to be concluded only when it reaches the knowledge of the person to whom it is made. Okay. Now, what about acceptance? An acceptance is sent through post by letter. Now, when do you say an acceptance is said to be complete? The acceptance aspect has been viewed from two angles. Number one, as against the offeror. Number two, as against the acceptor. As against the offeror, the moment the acceptor has posted the letter, immediately his obligation is fulfilled. Whose obligation? Acceptor's obligation. Supposing university has sent the examination hall ticket to you. You have sent the application form and the university has sent the examination hall ticket to you through post. If you have not received that examination letter, can you say that the university is at fault? Definitely not. It is only the postal authorities have to be approached and find out whether the address has been correctly written or whether the address that has been mentioned there is it correct address. So, university is not at fault when once they have complied with all your requirements and they have sent the letter to your correct address. So, university has fulfilled their obligation. So, an acceptance through post is said to be complete as against the offeror the moment the acceptor has posted the letter and when it is no longer possible for him to withdraw. When do you say acceptance is said to be complete as against the acceptor? As against the acceptor, communication of acceptance is said to be complete only when the offeror gets knowledge about acceptance through post. If acceptance has been sent through post, the offeror must get knowledge about the acceptance. Otherwise, the acceptance is not said to be concluded as against the acceptor. That is why we said, you see, acceptance must be communicated. First rule, first rule I said, acceptance must be communicated. It should reach the knowledge of the person to whom it is made. So unless it is communicated, it is not mere mental acceptance, is no acceptance. Therefore, acceptance is said to be concluded as against the acceptor only when the offeror gets knowledge about it. That means the offeror can file a suit against the acceptor only after receiving the letter of acceptance from the acceptor. So let us take a very important case law, a leading case law. Household Fire Insurance Company versus Grant. That's a leading case. In this case, Household Fire Insurance Company floated for mobilizing funds towards issue of shares. So, here is an applicant who wanted to become a shareholder in the Household Fire Insurance Company, and he applied for shares. The allotment letter was also posted by the Household Fire Insurance Company. But the allotment letter was not received by the applicant for shares. Then immediately the applicant filed a suit after not having received this. Then on analyzing facts, it was found out by the court that the company has already posted the allotment letter, but the allotment letter got lost through postal transit. Now in such case, can you say the contract has become concluded because the allotment letter has already been posted by the company, duly allotting the shares to the applicant. But the applicant has not received the allotment letter. Now you see, the shareholder, the applicant for shares, he makes an offer to purchase shares. The company is accepting to allot shares, and that is the reason as to why they have posted the allotment letter. So the company has accepted it. So what about the position of the company? The moment the company has accepted the offer made by the applicant for shares, his responsibility, that is the company's responsibility, is concluded because it has accepted and it has sent the allotment letter by post. So what all the acceptor has been expected to do, he has done. Therefore, communication of acceptance has become concluded here as against the offeror the moment the acceptor has posted the letter of acceptance, and when it is no longer possible for him to withdraw that letter which has already been posted. So that is why Hansen says an acceptance to an offer is just like a lighted match to a train of gunpowder. Here, gunpowder is compared to offer, and acceptance is compared to matchstick, lighted matchstick. The moment the gunpowder is lighted by the lighted matchstick, immediately contract bursts. Therefore here, if you do not want the contract to fructify, you should not allow the gunpowder to come in contact with the lighted match. Therefore, an offer can be withdrawn or revoked at any time before it is accepted. When once the letter of offer has been accepted and the acceptance letter has been sent by post, when it is no longer possible for the acceptor to withdraw, acceptance is said to be concluded as against the offeror. So, here, when a case was filed against Household Fire Insurance Company, stating that he has not received the letter of allotment, the court held acceptance is said to be concluded as against the shareholder offeror the moment the company has posted the letter. On the other hand, if the applicant for shares has not received the allotment letter, he should have immediately wrote a letter to the company stating that he has not received the allotment letter, or he should have verified from the post office. Now, having not done that and belatedly filing a suit at a later time, well, this will not be an answer to solve the problem. Therefore, you must understand that acceptance is said to be concluded, sent through post, as against the offeror the moment it has been posted. So, as against the offeror, acceptance is said to be concluded the moment the acceptor has posted the letter through post and when it is no longer possible for him to withdraw. Now, as against the acceptor, only when the letter of acceptance comes to the knowledge of the offeror. So, these are the two positions which you must understand very clearly. What are the two positions? An offer is said to be complete only when it reaches the knowledge of the acceptor. When do you say an acceptance is said to be complete? Completion of acceptance has been viewed from two angles. As against the offeror, when the acceptor has posted the letter, when it is no longer possible for him to withdraw. As against the acceptor, when the offeror gets knowledge about the letter of acceptance. Now, these are the two positions which you should definitely understand. Now, let us take revocation of an offer or revocation of an acceptance. So, when can you say an offeror can revoke his offer? An offeror can revoke his offer before his offer is accepted by the acceptor. So, that is why it has been rightly said, an acceptance to an offer is just like a lighted match to a train of gunpowder. The moment the acceptor has accepted the offerer cannot revoke the offer. He cannot withdraw the offer. But the acceptor is in an advantageous position. The acceptor can revoke his acceptance even if he has posted the letter of acceptance, because the mere posting of the letter of acceptance is not enough. On the other hand, it should reach the knowledge of the offeror. The offeror should get knowledge that his offer has been accepted. So there is a time lag between the date on which the acceptance letter has been posted and the date on which the offeror is going to get knowledge about the acceptance. Therefore, if the acceptor wants to revoke his acceptance, he can take time by forelock and can revoke the acceptance much earlier before it could be received by the offeror. In other words, if he sends immediately a telegram after posting the letter of acceptance, look here, I have posted a letter which has been revoked. I am now revoking the acceptance. Supposing he intimates it much earlier than the original letter could be received by the offeror, then revocation alone is said to be valid. So, in Hinton versus Fraser, that is exactly that has happened. The facts of the case have been succinctly summarized as follows. Take for example, X who is in Mumbai comes to Bangalore. He wants to purchase a bungalow at Bangalore. Now he chooses the bungalow and tells the owner of that building that he would like to purchase it, and they bargain, and it has been decided that he should purchase it for 1 crore. Then the prospective purchaser, he says that he would like to consult his advisors, and he will intimate it the very next day. Take for example, on 1st January, this fellow has come and he has bargained. He has said, before 3rd January, I will intimate you about my proposal to purchase this house for 1 crore. And he goes to Bombay. Then what happens? Then he accepts it on 2nd itself. This letter is actually received on 3rd. He has accepted to purchase this. Now what happens? On 2nd, he conveys his acceptance through telegram at 8 o'clock in the morning. Who? The prospective purchaser at Bombay. He intimates it. But 8 o'clock here at Bangalore, the advisors of the seller says, no, 1 crore is very cheap. You should have sold it for 1 crore and 50 lakhs. And therefore he revokes. Exactly, he sends the telegram, exactly 8 o'clock, the revocation. Revoking the original offer that has been made for 1 crore to sell the property. And there, that fellow sends it at 8 o'clock, his acceptance. And here, this fellow is sending his revocation of original acceptance by 8 o'clock. Similarly, 8 a.m. on 2nd of January. Now, how will you decide? is that a concluded contract? That's the question. Now let us apply the rule. When do you say an offer is said to be concluded as against the offeror? As against the offeror, an offer is said to be concluded only when it is received by the acceptor. Only when it comes to the knowledge of the acceptor. So now here, the person has come in person, the purchaser, the seller and purchaser, they have transacted the entire matter through bargaining in person, and he has gone there and assured to reply him. But here what happened? Now this letter of revocation is sent on 2nd January 8 o'clock. But at that time, this letter of revocation, though it is sent by 8 o'clock, by the seller, it reaches the purchaser only by 10 o'clock. Likewise, the letter of acceptance by the purchaser at Bombay is received by the seller only by 10 o'clock. So both the revocation letter sent by the seller and the letter of acceptance by the Maharashtra purchaser, they are received exactly by 10 a.m. both of these parties simultaneously. Now the question is whether there is a concluded. There is concluded contract. Sir, how can you say there is a concluded contract? At what time the Maharashtrian purchaser has accepted the offer to sell the house at Bangalore for 1 crore? 8 o'clock. At the time when the Bombay purchaser has sent his acceptance by 8 o'clock, had he knowledge about revocation sent by the seller at Bangalore? This revocation letter is received by the Bombay purchaser only by 10 o'clock. So at the time when he has sent the acceptance letter, he had no knowledge about revocation. Revocation is said to be complete. When do you say? Only when it reaches the knowledge of the person to whom it is made. So here, the acceptor to whom the revocation has been made receives the letter of revocation only by 10 o'clock. By 8 o'clock itself, he has accepted the original offer to sell the house for 1 crore. Therefore, there is a concluded contract. Hinton versus Preassessment. So, this is the next rule which I got to bear in mind. Then the last rule, an offer lapses before it is, an offer lapses when it is not accepted. So, an offer, when do you say? An acceptance must be, in other words, let us put it plainly and clearly. An acceptance should be made before offer lapses. When do you say an offer lapses? An offer lapses when it is not made in the prescribed manner. An offer lapses when it is not made in the prescribed manner. Now, what does the law of contract has to say about it? Section 7.2 says, when the offeror has prescribed a particular manner in which the acceptor should accept the offer, and in case the acceptor has accepted it in a different manner, still there is a duty on the part of the offeror to insist on the acceptor to accept his offer in the particular manner in which it has got to be accepted within a reasonable time. If the acceptor has not accepted in the prescribed manner, then you say the offer is said to have lapsed. So, and that too within a reasonable time, he should, the acceptor must take reasonable time. He cannot take time at his own leisure. So, he should immediately inform, look here, the acceptor, see, offeror makes an offer, the acceptor accepts it in a different manner. Immediately the offeror should point out to the acceptor, you have not accepted in the manner in which I wanted you to accept. Therefore, accept it in the manner I wanted you to accept. This is what section 7.2 says. If he fails to inform him within a reasonable time, then it is said to be valid. The original way in which he has accepted, it is deemed to be valid. So, an acceptance must be in the prescribed manner. Second rule, acceptance must be within the prescribed time. Ramsgate Hotel Company versus Montefiore. An offer has lapsed because it has not been accepted within the prescribed time. Now, here is a case where a person applied for shares in the month of June. He forwarded his application for allotment of shares in the month of June. But the company allotted the share only in the month of December. As per rules of company law and sections, it should be sent within 3 months. That is an appropriate section, 113, 114, so on and so forth. But if the allotment has not been made within the prescribed time, the allotment is said to be invalid. So, here is a person who has applied for shares and wanted the shares to be allotted within the prescribed time. Time is considered to be the essence of the contract. Therefore, here when it has not been allotted within the prescribed time, then the offer is said to have lapsed. So, and acceptance must be made within the prescribed time. The next sub-rule is acceptance and an offer lapses by revocation, which may be express or implied. There is one important case with regard to revocation, rejection. An offer lapses by revocation. There is a leading case, Dickinson versus Dodds. The facts of the case have been succinctly summarized as follows. Now, in this case, Dodds offered to sell Dickinson his house for £800 with a promise to keep the offer open till 12th June. However, Dodds on 11th June sold the estate to one Mr. Allen. When Dickinson made up his mind to accept the offer by the end of 11th June, he came to know that Dodds has sold the estate to Allen. In a suit filed by Dickinson, the court held that the entire transaction was only in the nature of a promise. And revocation need not be expressed. It could be inferred from the conduct of the parties. There is no necessity on the part of Dodds to communicate his rejection by express letter to Dickens. It can also be implied by his conduct. That is what the law says. So therefore, an offer lapses by revocation. An offer lapses by counteroffer. What is this counteroffer? In a leading case, Hyde versus Wrench, the facts have been briefly explained as follows. The defendant offered to sell his estate for £1,000. The plaintiff agreed to buy that for £950 by bargaining with the defendant. Now, thereupon, when he could not satisfy the defendant, immediately the purchaser filed a suit. I have already agreed because originally he was bargaining to purchase it for 950 because when once the seller made an offer for 1,000, he started bargaining, why not you sell it for £950, and that was not agreed by the seller, and immediately the plaintiff actually made, all right, I'll purchase it for £1,000, why not you now sell? Then he said that has lapsed. The offer which I made originally, it has lapsed. Take for example, we are purchasing vegetables from vegetable vendor. We go to a vegetable shop. We ask the vendor, what is the price of this baingan? What is the price of this vegetable? Tomato. Take for example tomato. That fellow says, it is 50 rupees, sir. Oh, this is too much. 50 rupees is too much. No, I don't want to buy it. Then he goes to the next shop. And the next shopkeeper says, no, it is 55 rupees. Then originally, oh, that fellow says 50 rupees and you are saying 55 rupees, I would like to go to him. And when you go there, you know, no sir, it is now 55 rupees. In as much as you have gone to the other shop and verified and all that, no sir, no. Well, what happened? The original offer, yes, that has lapsed. So, counter offer, when you wanted to sell it at 50 rupees, you wanted to actually revoke it and you never wanted to purchase it. You bargained it 45 rupees and then went to the other shop, and when he told 55 rupees, once again you come to purchase at 50 rupees. No, original offer has been lapsed. So that is what he says. He is entitled to say like that. An offer lapses by counter offer. That is the case of Hyde versus Wrench. But in other case where Crossoffer has been distinguished from counteroffer. Tin versus Hoffman, that is the case. Here is a case where simultaneously the seller makes an offer to the buyer to sell it for 500 pounds. And the buyer makes exactly at the same time, in respect of the same subject matter simultaneously, to purchase it at 500 rupees. Now, is there a concluded offer, concluded contract? Certainly not. Cross offer. How to explain cross offer? Here is a hero who is in search of the heroine. He is seated in the train bound for Chennai from Bangalore. Then the heroine is seated in the train bound for Bangalore from Chennai. The train stops at Jolarpet. Both the hero and heroine, they never knew that the other one is seated in the train bound for Chennai, and the heroine is seated in the train and the hero is seated in the train bound for Bangalore. So here you find it is what is known as cross offer. Both of them are making an offer against each other simultaneously with regard to the same subject matter with the same intention. Therefore, it is a cross offer. Therefore, there is no concluded contract. So, here you must understand an offer lapses by counter offer. Next one. Acceptance must be absolute and unconditional. What do you mean by that? No, I do not want this kind of goods. I want, you qualify the goods. Supposing the seller wants to sell the goods and you want some improvement to be made. You fix a handle over this box. One more handle, otherwise I will not. So you are qualifying your acceptance. Supposing you say, subject to the fulfillment of the condition, I will actually take these goods. Well, you are qualifying. A qualified acceptance is no acceptance, a conditional acceptance. Now, in respect of conditional acceptance, you have got two types of acceptance. That is, condition precedent and condition subsequent. Let us humorously narrate the case. Here is a girl who wants to enter into a marital alliance with a boy. The parents are arranging, is an arranged marriage. Now the girl asks the question to the prospective bridegroom. Now, do you know cooking? That fellow says, I do not. Now this girl says, all right, I will give you 1 month time. I don't mind marrying you unless you learn cooking. Now this is what is known as condition precedent. That is, I don't mind accepting your offer provided you fulfill this condition. Unless you learn cooking, I will not marry you. Well, this is condition precedent, it is valid. Condition subsequent. Humorously again, if both the father of the girl and father of the boy, they enter into a marital alliance stating that we propose to give our daughter and son by way of marriage, provided we should become grandfathers within 2 years. Becoming grandfather within 2 years does not depend upon the grandfather. That transaction, it depends upon the husband and wife and by God's grace. So this is what is known as condition subsequent. What is the difference between condition precedent and condition subsequent? Condition subsequent is after acceptance on the offer, condition must be fulfilled. Condition precedent is before acceptance on the offer, condition must be fulfilled. So condition, so we have got leading case here, That is the case of these two cases, Raman Boy versus Gashiram. It's a reported case. In that case, a person wants to purchase shares in a company. He says, I don't mind purchasing shares from your company, but you appoint me as a cashier before I purchase. If you are prepared to appoint me as a cashier in your company, I don't mind purchasing huge shares from your company. Well, the company allots the shares without appointing him as a cashier. Immediately he filed a suit. See, I have not been appointed as a cashier. How can he allot that? The court also says he has imposed a condition. Before allotment of shares, he should have been appointed as a cashier. How can he allot shares without appointing him as a cashier? Well, that is what is known as condition. In the other case, condition subsequent, that is the case of Motilal versus Thakur Lal. In that case, a person agrees to purchase shares provided dividend is declared. Subsequent to purchase of shares, dividend must be declared. Now, declaration of dividend does not depend upon the ordinary nature of events. It depends upon the way in which the company is successfully conducting the business. If the company conducts the business successfully, it will give profit. It yields profit. So, declaration of dividend depends upon the profit position. So, in Motilal versus Thakur Lal, so declaration of dividend is known as condition subsequent. After allotment of shares, dividend must be declared. Then the next point is, last point, that is acceptance sent through email, acceptance sent through telephone. Now, when do you say the acceptance is said to be concluded? Mere sending message through email, that is not enough. It should reach the person to whom it is made. So, the contract gets completed not at the place where the message is sent, but at the place where the message is received. Yentor versus Miles. There is another case also, Bhagavan Das Kedia versus Giridhari Lal. So, here you must understand, mere sending the message through telephone, that is not enough. It should actually be received by the other side. That is why invariably in commercial parlance we confirm the letter. This is with regard to the telephonic conversation the undersigned had with your purchase officer on such and such date at such and such time, during which conversation we have agreed to the following proposals and conditions. Now, condition number 1, that the goods will be delivered on such and such date, that the good will be taken delivery of at such and such station, and the complaint, anything with regard to damages and other things should be made within a week's time from the date of receipt of these goods, so on and so forth. So, we confirm it. Why we want to confirm? Whether the confirmation actually signifies that the transaction, whether the letter has been received, the message has been received properly. So, we must first of all know, even while sending any message through telephone, whether it is received by the proper person. That must be very. Supposing you are going on enumerating various conditions to a person who is only an attender in the office, then it is not complete. The transaction itself gets completely stultified, defeated. Therefore, any message of acceptance or offer sent through telephone must be received by the other side. It is the place where the message of offer is received. At that place only the contract gets concluded. I think if you remember these important salient points, to a certain extent you have got a comprehensive knowledge about offer and acceptance. Thank you very much.